we have an update to the $100 million lawsuit. Magnus Carlsen's lawyers have responded and they have asked the court to dismiss Hans Niemann's claims. So let's go through the document. There is a table of contents which was missing in the lawsuit. There's a preliminary statement and background argument. Now, there are like five parts to the argument. First is that anti-SLAPP statute applies here. So I'll explain what anti-SLAPP is. The second is for counts one and two, how Niemann's claims fail on counts one and two, and the three remaining claims, count three, four, five, in the next three parts, and then the conclusion. So this is filed in the same style that Hans Niemann's lawyers, in the same language and style that Hans Niemann's lawyers filed the complaint. As you can see, if you dive right in, let's go to page one of the introduction. After years of trying to curate a reputation as the bad boy of chess, plaintiff Hans Niemann wants to cash in by blaming others for the fallout from his own admitted misconduct. So the whole of this document basically says that Hans Niemann admitted to cheating. He is the reason why he got into this big hole where people no longer give any respect to him. So he dug his own hole, he made his own bed. It's not Carlsen who did it, it's Hans Niemann himself. That's what the lawyers basically say here. But rather than dealing with the unsurprising consequences of his own actions, Niemann now seeks to shift blame to reigning world chess champion Magnus Carlsen and others, claiming a wholly implausible conspiracy to defame and boycott Niemann that somehow damaged his already dubious reputation to the tune of $100 million. So, like I said, that there is no real harm done. It was already done by himself. Niemann's claims all fail on the face of the amended complaint. Even accepting all of his allegations as true, Niemann cannot escape his own admissions that he has cheated in chess more than once, and as recently as 2 years ago. Indeed, cheating was an indelible part of Niemann's chess career and reputation well before the events alleged in the amended complaint. So, this is setting the setting the background for the judges, those who are not really familiar with chess and how relevant cheating in chess is, how bad cheating in chess is. It basically portrays Hans Niemann as a bad figure who has been cheating his entire life, and this event is just created by his own actions. So let's just go forward a little bit. His first admitted instance of cheating happened at age 12, not long after he received his first chess title of Federation Master at age 11. And he became a Grandmaster at age 17, roughly a year after another admitted instance of cheating at age 16. In 2020, Chess.com banned Niemann from its platform for 6 months for cheating, something that Niemann at the time acknowledged was more than completely fair. So they're just portraying based on facts that he cheated here, here, here. He himself has admitted to all of this, so there is no fight there. Niemann attempts to minimize his history of cheating by claiming that he was simply experimenting with a chess engine. So he had downplayed it in the complaint, but that's not the case, is what the lawyers are saying. Cheating is cheating. It's a big crime in chess. Despite Niemann's attempt to pretend otherwise, his amended complaint leaves no doubt that his history of non misconduct is the reason that top ranked chess players and tournament organizers question the integrity of his play. It's his own reputation that he damaged by uh, cheating in online events and admitting to it. Even accepting Niemann's baseless allegations as true, his fatal admissions and lack of plausible allegations make it impossible for him to state any valid claim against Carlsen. So now they are just briefly explaining the contents of the argument. First, the court should immediately dismiss Niemann's four state claims pursuant to Connecticut's anti-strategic lawsuits against public participation, anti-SLAPP statute. So basically, SLAPP stands for strategic lawsuits against public participation. So this anti-SLAPP laws are basically intended to prevent citizens from intimidating other people. Like, let's say you have a problem with me. Let's say you are rich and I'm poor. When you threaten to file a lawsuit against me, then that affects my decision making. That's like a threat. So when someone uses their First Amendment right, their free speech, another person cannot file a lawsuit for that. So, anti-SLAPP statute is to prevent individuals from threatening lawsuits or filing lawsuits against public participation. And one important thing is the anti-SLAPP laws in Connecticut is more rigid, more strict than in Missouri. This complaint was filed in Missouri, but Hans Niemann resides in Connecticut. So they're saying that Connecticut laws should apply here. Connecticut's anti-SLAPP statute is a substantive state law that applies here because Niemann admits in his amended complaint that he is a public figure. So this law applies for public figures, and he is suing Carlson and others for speech that he acknowledges is a matter of public concern. So anti-SLAPP laws apply here is their first argument. So these counts 1, 2, 4, 5, the 4 counts of complaints should be dismissed, is what the lawyers are saying. Second, Niemann's defamation claims fail to state plausible claims for relief. So he hasn't mentioned when Carlson said what exactly, if it means, and he hasn't proven that Carlson had actual intent to harm his career. So that's what they're saying. They explain this in detail. As a public figure, Niemann must allege either that Carlson knew the statements he allegedly made were false or was reckless about whether they were true. So there is a concept called actual malice. If someone knows that you haven't done something and they are publicly saying that you did it, then that is actual malice, and that is punishable when according to defamation laws. But here there is no actual malice, is what the lawyer is saying. The lawyers are saying Niemann's own allegations show he cannot meet this high bar. Read liberally, Niemann appears to allege that Carlson defamed him by insinuating that Niemann cheated during the Sinfield Cup. But Niemann's own amended complaint admits that Niemann has cheated in chess games before. Under these and that he played Carlson prior to Sinfield Cup. Under these circumstances, Niemann cannot plausibly allege, much less prove, that Carlson knew that Niemann did not cheat or Carlson's cheating concerns were insincere. So there is no actual malice and there was no recklessness. That's what they're saying. Moreover, many of the statements that Niemann attributes to Carlson are not actionable for other reasons, including because they at most reflect Carlson's opinions. They are not actionable. They are just Carlson's opinions and his behavior. So they cannot be punished. I mean, Carlson cannot be punished for his opinions, is what they're saying. Now, in the third and fourth part, the counts 4 and 5. Niemann's claims of tortious indifference and civil conspiracy. That's counts 4 and 5 in the lawsuit. Basically, he has alleged that there is a huge conspiracy between Chester.com, Nakamura, and Carlson in defaming him. So they're saying it likewise failed because they based on the same alleged conduct as his defective defamation claims, and because Niemann has not alleged the essential elements of these claims. So we'll get into detail of that. They explain it later on. Fourth, Niemann's antitrust claim. Antitrust claim basically means that in the complaint, the count 5 was antitrust, which is basically that these business entities did not allow or restricted Hans Niemann from doing business, from doing trade. It affected his profession because of these 3 entities, Magnus Carlsen, Chester.com, and Nakamura's interference. So Niemann's attempt to make a federal case out of implausible state law defamation claims fails at every step of the analysis. He does not allege any harm to competition. Instead, the only injury he asserts results from the harm he caused to his own reputation through his own admitted cheating. He fails to plead any agreement among the defendants, much less a plausible one. So basically, they're saying that he hasn't proven, or there is no way for him to prove that there has been some agreement between the defendants to defame him, to not let him do his trade, which is chess. For all these reasons, this court should dismiss all of Niemann's claims against Carlson. And because Niemann cannot salvage those claims, the dismissal should be with prejudice, which means the party that accused the others should pay for the attorney's fees and costs in connection with the motion. This court also should award Carlson's attorney's fees and costs in connection with this motion, as is required under Connecticut's anti-SLAPP statute. So anti-SLAPP statute is a very important part of this response. So they're laying the background here next. Magnus Carlsen is the world's number one chess player and has been the world chess champion since 2013. And they lay the whole thing out. Most of these things you would already know, right? What are the issues? I mean, who's Carlsen, who's Niemann, and when did the accusation happen? This is a very important part of the complaint. Niemann bases his state law tort and federal antitrust claims on a parade of alleged grievances flowing out of what he perceives as Carlsen reigning on his career's biggest victory. In particular, he complains that Carlsen purportedly spoke with Michael Khodorkovsky, the executive director of the Grand Chess Tour. Sinquefield Cup was part of Grand Chess Tour, to accuse Niemann of cheating, demand Niemann be disqualified, and request that Khodorkovsky dramatically enhance the anti-cheating measures at the Sinquefield Cup. Niemann also alleges that Carlsen then withdrew from the Sinquefield Cup entirely and tweeted about it in ways Niemann found objectionable. Later, Carlsen reserved only one move in an online match against Niemann in the Julius Baer Generation Cup. So they are basically laying out the whole picture. They are just summarizing what are the allegations, what actually happened. He then shared his thoughts about his Infield Cup match against Niemann in a September 26, 2022 tweet. Finally, Carlsen allegedly linked Niemann to another admitted chess cheater, Maxim Glugi, in an interview. In his 5 count amended complaint, they mention amended complaint everywhere. So they're not letting the fact that the lawyers of Niemann had to amend the original complaint because there was a technical flaw. They keep reminding everyone of that. Niemann claims that some or all of these words and actions, he does not specify exactly which ones constitute slander or libel. He further, so slander is basically oral allegations, oral defamation, and libel is written defamation. He further contends that through the alleged defamation, Carlsen and others tortiously interfered with his opportunity to play competitive chess in the 2022 Chess.com Global Championship, Tata Steel Tournament, and a private match against Grandmaster Vincent Kiemer. Niemann also accuses Carlsen and the other defendants of conspiracy, alleging that they schemed and agreed amongst themselves to repeatedly defame Niemann to members of the chess community and the public at large. And he alleges that the defendants violated Section 1 of the Sherman Act by acting in concert to improperly refuse to deal with Niemann. The Sherman Act is applicable when there is an interference in someone else's trade, when there is no fair ground for all uh, competition to survive together, when one particular company is uh, pushing off the other company from the trade or business. But rather than stating any valid claim against Carlsen and the other defendants, the amended complaint only highlights the stark difference between how Niemann wants the chess world to perceive him as an American chess prodigy, like Fischer, that's the reference, and the disappointing reality. Now comes the main part, which is the argument. So, in the argument, first, anti-SLAPP statute applies here. That's the main part of this argument. So, for counts 1, 2, 4, and 5, libel, slander, tortious interference, and antitrust, uh, the anti-SLAPP statute applies. So I already explained what is SLAPP and what is anti-SLAPP laws. It's to prevent anybody from threatening a lawsuit or actually filing a lawsuit against public participation. So if someone is exercising their free speech and if someone else threatens them with a lawsuit, then anti-SLAPP statute applies there. Connecticut law offers Carlsen an anti-SLAPP defense to all of Niemann's state law claims. Specifically, Connecticut's anti-SLAPP statute broadly protects parties from meritless lawsuits designed to chill free speech. Chill language there in the law by offering defendants like Carlsen the opportunity to file a special motion to dismiss at the beginning of a case. So if there is no merit in that case, and if you have the option to file for dismissal at the beginning itself. That's why they file for dismissal basically. And they've mentioned they're more thorough basically. Compared to Niemann's lawyers, this is a more thorough statement. First of all, there's a table of contents, which makes it easier to read. And now here they've mentioned exactly what the issue regarding anti-SLAPP is. This substantive shield would be unavailable to Carlsen under Missouri law because Missouri's anti-SLAPP statute is inapplicable here. So the lawsuit was filed in Missouri, but Carlsen's legal team is saying that Missouri's anti-SLAPP statute is inapplicable here because there is an outcome determinative conflict between the defenses available under the laws of Missouri and Connecticut. Why do they say that the laws of Missouri, anti-SLAPP of Missouri, does not apply here? Because Hans Niemann resides in Connecticut. So let's go down. Resolving the conflict between Connecticut and Missouri law requires this court to apply Missouri's choice of law rules. Missouri determines choice of law issues in tort actions by considering the following factors to identify the state having the most significant relationship to a particular claim. Four factors: the place where the injury occurred, the place where the conduct causing the injury occurred, the domicile, residence, nationality, place of incorporation, and place of business of the parties, and the place where the relationship, if any, between the parties is centered. So, based on these factors, you are supposed to decide which anti-SLAPP law of which state applies to this particular claim. As applied to Niemann's specific tort claims, the place where the injury occurred, here, Connecticut, where Niemann resides, is the most important consideration in determining which state bears the most significant relation to each claim. Accordingly, Connecticut's substantive law applies to Niemann's state law claims and thus to Carlsen's defenses. So they're basically saying that Connecticut anti-SLAPP laws should be applied here because Niemann resides here and this is where the injury happened. Injury as in the defamation, the effect on Niemann's fame. In particular, for Niemann's slander and libel claims, the residence of the party allegedly defamed is the most important consideration in choosing the applicable law. Whereas here the plaintiff claims widespread dissemination of the allegedly defamatory matter. The main factor, according to the laws, the residence of the party allegedly defamed, which is Connecticut. So that should be considered here, not the citizenship of the remaining parties, which is widespread, according to the complaint. Let's go down. Connecticut law independently bears the most significant relationship to Niemann's tortious indifference and civil conspiracy claims because, just as for defamation, courts employing the most significant relationship test gives the most weight to the plaintiff residence as the place where the injury occurred. So they're just strengthening the claim that Connecticut law should apply here in this case. Missouri choice of law rules that Missouri substantive law applied to a tortious indifference claim brought by a plaintiff residing in Missouri, where the other parties involved were in Missouri and California, and the alleged indifference was conducted over telephone and mail. Then Missouri laws would apply. As with Niemann's defamation claims, any injury was felt in Niemann's state of residence, Connecticut. And even if the most significant relationship analysis was inconclusive, Missouri law establishes that trial court should apply the substantive law of the place where the injury occurred, which again points to Connecticut where Niemann resides. So that is the first part of the argument, that Connecticut's anti-SLAPP laws, which are fairly strict, should apply here. In B part of the first segment, Niemann's state law claims fail under Connecticut's anti-SLAPP statute. So first they claim that Connecticut anti-SLAPP law should apply, and in the second part they say that according to Connecticut's anti-SLAPP statute, Niemann's claims are false. They fail. So let's see how. This court should dismiss Niemann's state law claims under Connecticut's anti-SLAPP statute because they are based on Carlsen's exercise of free speech and because Niemann cannot demonstrate with particularity any circumstances giving rise to a meritorious claim or show probable cause that he will prevail. So it's Carlsen's right to exercise his free speech. And there is no meritorious claim to the argument that Carlsen already knew or there was actual malice involved. Many courts have held that various states' anti-SLAPP statutes apply in federal court because the statutes serve the distinct function of protecting those specific defendants that have been targeted with litigation on the basis of the protected speech. So it applies in federal court as well, they're saying. Let's go down. So they explain how Niemann's claims are false. Connecticut's anti-SLAPP statute would apply in Connecticut State Court had Niemann's suit filed there. So for the anti-SLAPP statute of Connecticut to apply, they have to show that Carlsen's exercise of free speech was done, and second, that he is a public figure, that Niemann is a public figure. So they here go on to show how Niemann himself has considered himself a public figure, that he is a public figure. So this law should apply here. Let's go down. Niemann's allegations also establish that he is a public figure, meaning that speech about him in that capacity constitute a matter of public concern under Connecticut's anti-SLAPP statute. So they are just mentioning the different facts that show that he is a public figure, and that's why this law should apply here. Here they've done a technical thing where Connecticut's anti-SLAPP statute is substantive and it does not conflict with the federal rules. So they mention how it does not conflict; it actually supplements federal rules and should be applied in federal court, is what they're saying. So this part is not that important; it's very technical. Let's go down. Here they've mentioned state law claims fail to satisfy the rigorous showing required by Connecticut's anti-SLAPP statute. So if you are threatening to file a lawsuit or you file a lawsuit against someone for exercising their right of free speech, saying that they've defamed you, then you have to show rigorous amount of proof and evidence to show that there was actual malice involved or there was recklessness in the person's speech or in writing. Because Niemann has not met and cannot meet his burden to demonstrate to the court that there is probable cause that he will prevail on the merits of the complaint with the particularity that Connecticut law requires, each of his state law claims should be dismissed. So they're saying that he cannot prove and he hasn't proved or demonstrated that there is probable cause. So there is no merit to the complaint, should be dismissed. First, Niemann has failed to adequately allege essential elements of each of his state law claims. And on the face of those claims cannot show probable cause that he will prevail. In this context, there's some technical details. Let's go down. So basically, they're saying uh, Niemann's complaint is missing the factual allegations needed to support his state law claims. There is no factual allegations in the complaint. It does not mention where, who said what exactly, which are the defamatory statements that Carlson made. It's not mentioned there. So there is no grounds for continuing this complaint. That's the first part of the argument. The second, Niemann cannot overcome Carlson's defenses. So Carlson's defenses are mainly based on anti-SLAPP statute of Connecticut, and Niemann couldn't overcome, so it should be just dismissed, is what they're saying. Now, coming to the second part, Niemann's defamation claims fail for the separate reason that Niemann has failed to plausibly allege them. So the counts 1 and 2 are libel and slander. So Niemann is required to plead the necessary elements for each separate libelous or slanderous statement. Those elements are Carlson published a defamatory statement. The defamatory statement identified Niemann to a third person. The defamatory statement was published to a third person. Niemann's reputation suffered injury as a result of the statement. So these things Niemann has to show, but it is not shown. In addition, because Niemann is a public figure, he also must allege and demonstrate that Carlson acted with actual malice. So first, they have proven that, like, demonstrated that Niemann is a public figure. In anti-SLAPP law, when someone says something about a public figure, and if the public figure wants to file a lawsuit, then you have to show actual malice, right? That the person who made the defamatory statement knew that what he's saying is false, but still said it or wrote it. That is actual malice. So it is not here. Carlson knew that. I mean, Carlson had opinions that Niemann has cheated, and he mentioned that there was no actual malice. Okay, now comes a very important part of the argument. Niemann fails to specifically identify defamatory statements made by Carlson. The jumbled morass of asserted statements and conduct by Carlson alleged in the amended complaint fails to meet Niemann's burden of specifically identifying what allegedly defamatory statements were made by whom and to whom. So it was not identified exactly which statements were defamatory and by whom and to whom and when. That was not shown in the complaint that was filed by Niemann. So that's the first part of that argument. Second, Niemann fails to plausibly allege that Carlson acted with actual malice. So I've already explained this, right? Actual malice requires that statement, when made, be made with actual knowledge that it was false or reckless disregard of whether it was false. In this case, Niemann himself has admitted to cheating in chess. So Carlson could not have been thinking, yeah, he hasn't cheated, but still let me say this. That was not the case. That is pretty obvious. That's what they're saying. Given the allegations in the amended complaint and Niemann's acknowledged history of cheating, Niemann has failed to and cannot plausibly allege that Carlson knew his purported statements were false, had an awareness of their probable falsity, or entertained serious doubts as to their truth. That is not the case. What they're saying, Carlson believed what he was saying, so there is no actual malice. Niemann claims that Carlson falsely accused Niemann of cheating at the Sinfield Cup. but he does not allege and cannot allege any facts to support this conclusory assertion. If you have to show that this was a false accusation, you have to show that he didn't cheat, which Niemann cannot do. Highlighting the lack of any such allegations, Niemann relies exclusively on post hoc sources such as the claimed lack of statistical evidence of cheating and statements made by Sinfield Cup organizers that there was no indications of cheating. These after the fact sources could not have informed Carlsen's personal impressions and evaluation of Niemann's play at the Sinfield Cup match. So this was, yeah, that's a very nice argument. Yeah, it's these lack of statistical evidence and organizers saying there was no indication of cheating that happened later, and Carlsen withdrew from the tournament before, and so Carlsen's opinion cannot have been formed based on what happened later, right? So there was no malice there, is what they're saying. There was no disregard, there was no malice. Let's go down. Further, Niemann's own allegations demonstrate that each of Carlsen's allegedly defamatory statements were personal impressions. So they were just opinions, personal impressions. Even the complaint mentions that. Finally, Niemann's bold assertions that Carlsen acted with reckless disregard are insufficient to plead actual malice, and they're particularly implausible given the numerous facts alleged by Niemann, undercutting his insistence that Carlsen somehow knew his allegedly defamatory statements were untrue. On the contrary, Niemann's own allegations show that he is trying to hold Carlsen liable for sincerely held beliefs that Carlsen formed based on his own interactions with Niemann and Niemann's reputation. So these were Carlsen's opinion. His actions were based on his beliefs, and there was no malice. There was no intentional hurt being done there, is what they're saying. Third part of the argument, the allegedly defamatory statements are not actionable in any event. Even if these statements were true, even then they're not actionable. So they show this specifically. Niemann's failure to identify specific statements of plausibly alleged actual malice is on its own grounds to dismiss his defamation claims. But these claims also fail for the separate reason that none of the allegedly defamatory statements is actionable. While Niemann's amended complaint obfuscates the subject of his grievances, he appears to complain that Carlsen defamed him by three things: withdrawing from the Sinfield Cup and resigning from the Julius Baer Generation Cup game, expressing concerns about Niemann's cheating to Kodarkovsky, the chess tournament official at the Sinfield Cup, expressing his opinion that Niemann cheated at the Sinfield Cup through the tweets by Carlsen. Even if true, none of these complaints give rise to a defamation claim. So they show how. First, as a matter of law, Niemann's allegations regarding Carlsen's resignations in various chess tournaments cannot support a defamation claim. So he resigned. That cannot mean that he intended to defame Hans Niemann. That is his right. Defamation is comprised of the torts of libel and slander. Slander is oral defamation, libel is written defamation. Accordingly, to the extent Niemann's defamation claims are premised on conduct such as Carlsen's tournament or game resignations, those claims fail as a matter of law. So that is not libel or slander. He resigned. That's up to him. That's his right. Second, the communication with the tournament official, Kodarkovsky. Carlsen's alleged statements to tournament officials are protected by qualified privilege. So it's protected. Those claims cannot be considered defamatory. Second, to the extent Niemann's defamation claims are based on Carlsen's alleged statements to chess tournament officials, those statements are all protected by qualified privilege. Qualified privilege exists where, as here, there is an interest to be upheld, a statement limited in scope to this purpose, good faith, a proper occasion, and a publication in a proper manner to proper parties only. So qualified privilege applies here because it was a tournament, it was a public event, and let's say Carlsen and the official, they have a common interest to be upheld, which is not to allow cheating, to keep the integrity of the tournament. Indeed, even assuming that Carlsen in fact expressed concerns about Niemann's cheating to Kodarkovsky, the executive director of the Grand Chess Tour, such statements would not be actionable. Niemann's own allegations show that Carlsen and Kodarkovsky had a common interest in preventing cheating at the Sinfield Cup, which is one of the Grand Chess Tour's featured events. And hence, the alleged statements to Kodarkovsky are thus protected by qualified privilege. So they cannot be considered defamatory. They are protected by privilege. Let's go to the third part. Carlsen's alleged statements are non-actionable opinions. And now coming to the tweets. His tweets where he mentioned he accused Niemann of cheating. Finally, Niemann's claim should be dismissed because he alleged defamatory statements at most amount to non-actionable opinions. Statements of opinion, even if negative or otherwise harmful, cannot, as a matter of law, form the basis of a defamation claim. They were just Carlsen's opinions and cannot form the basis of a defamation claim. As discussed earlier, Niemann's own allegations demonstrate that Carlsen's allegedly defamatory statements constituted his own personal impressions based on his first-hand observations and what was already known throughout the chess community. So these were beliefs and opinions that Carlsen made according to his own observations with this interaction with Niemann, and what they already knew, what people already knew, because Niemann has already been banned before from chess.com. Now, coming down to the claim for tortious interference, count 4, and then count 5. Like his defamation claims, Niemann fails to adequately allege a claim for tortious interference. A tortious interference claim requires a business relationship between the plaintiff and another party. The defendant's intentional interference with the business relationship while knowing of the relationship, and as a result of the interference, the plaintiff to suffer actual loss. So this much has to be proven to allege tortious interference. First, Niemann has not alleged that Carlsen had actual knowledge of any alleged contracts or business relationship Niemann has. Nowhere in the amended complaint does Niemann allege that Carlsen had actual knowledge of, for example, Niemann's opportunity to attend the Tata Steel chess tournament or his desire to play against Kima. So Niemann has not shown that Carlsen already knew or had knowledge about Niemann's future contracts or business relationship. So if Carlsen didn't know that, how could he affect it in a planned manner with his business friends? Second, Niemann has not adequately alleged that Carlsen had any intent to interfere with any contracts or business relationships. To allege an intent to interfere, a plaintiff must plead at least some improper motive or improper means. In other words, the plaintiff bears the burden of alleging lack of justification on the part of the defendant for interfering. So if Carlsen interfered, then you have to show that he interfered here. The burden of proof is on the person who is accusing the other person of interfering in his business. So let's go down. Finally, Niemann has not alleged any factual basis for his contention that Carlsen's alleged conduct was the proximate cause of his purported injury. So basically, it means that they're saying Carlsen's actions, how Niemann has not shown or has shown any facts to prove that Carlsen's actions affected Niemann's injury, which is defamation, which is effect on his reputation, such as being disinvited from the tournaments and the match against Kimmer. Instead, Niemann's own amended complaint supplies several other more likely causes for the rescinded tournament invitations, including his own admissions of past cheating. So he admitted to cheating, and that must have affected his future contracts, his future invitations to tournaments, etc. It was not Carlsen's doing; it was just Niemann's doing, is what they're saying. The court should dismiss Niemann's tortious indifference claim. Now, coming to the last count, which is civil conspiracy. When two or more parties combine and they conspire against another person who's in the market, in the trade, and take them out of the market, that is civil conspiracy. Basically, not allowing someone to do fair trade or business. So you can see here, because he has failed to adequately allege an underlying tort as is required to state a claim for civil conspiracy. Niemann also has failed to sufficiently allege the required elements for civil conspiracy under Connecticut law, a combination between two or more persons to do a criminal or unlawful act, or a lawful act by criminal or unlawful means. An act done by one or more of the conspirators pursuant to the scheme and in furtherance to the object, which act results in damage to the plaintiff. He makes no allegations of an agreement or combination among the defendants, relying entirely on conclusory statements that provide no specificity. So there is no proof, or he has not demonstrated that there was an agreement between the parties, which is chess.com, Nakamura, and chess.com, and Magnus Carlsen. The only allegation he provides in his failed effort is that his sudden ban by chess.com was at the precise time Carlsen accused Niemann of cheating against him, and that Nakamura's commentary came after Carlsen's tweet regarding his withdrawal from the Sinfield Cup. The allegedly close timing of these unilateral actions does not amount to plausible allegations. So this is not enough proof, is what they're saying. It's up to the court to decide. So that and Niemann has not plausibly alleged an antitrust claim. As discussed in section 1 of the chess.com motion, which is incorporated by reference, Niemann's federal antitrust claim fails as a matter of law. This claim is nothing more than an artful repackaging of Niemann's defective defamation and related state law claims, which fails for at least the three independent reasons discussed in the Chesterton motion. Niemann does not plausibly allege an agreement among the defendants. Niemann does not allege the threshold requirement of antitrust injury. So there was not enough injury because of antitrust. He has not been affected by the other business guys. Niemann does not allege that any purported agreement unreasonably restrained trade under either the per se rule or the rule of reason. So there were no facts as to show that there was conspiracy, is what they're saying. So now the conclusion. For the foregoing reasons, the court should dismiss each of Niemann's 5 claims against Carlsen. Because all of Niemann's claims against Carlsen suffer from fundamental inadequacies that cannot be cured, Niemann's claims should be dismissed with prejudice. So they have made a very thorough statement here, and all the laws have been referenced as well at the beginning. And this is the end of the document. It is a 34-page document where as we just saw, they have taken down each of the 5 counts of complaints made against or claims made against Carlsen. So the summary of all of this is the first thing, that Connecticut's anti-SLAPP law applies there, and it is intended to prevent anybody from threatening a lawsuit for making a public statement against a public figure. So that applies there. And then there is not enough proof. The second part of their argument is there is not enough proof to show that each of these counts is valid. And they have went on to explain each of that in detail. So that was Magnus Carlsen's legal team responding to Hans Niemann's complaint, amended complaint, I must say. And it looks like it's personally, I feel it would get dismissed, the $100 million lawsuit, and Hans Niemann would have to pay for Magnus Carlsen attorney fees, and it would just be that. Let's see how things unfold.